In this panel, what we want to do is really bring in a voice that really, I don't think has been brought up nearly enough, and often isn't brought up nearly enough when we talk about these big transformational changes, and that is the role of lawyers, who are the ones who, after all, have to navigate these processes. And the lawyers today have been thrown into a world, quite frankly, that none of them either expected or had time to prepare for. And yet they've had to continue to represent their clients in this new phase. So what we're going to do here is we have four amazing advocates here, two from the US side and two from the other side of the pond on the UK. And I have told them that what I want here is a conversation. So I've got some questions and some things that I hope will help to steer the discussion, but I've encouraged each of them to please feel free to jump in, to interrupt, to give their views, because I think that will give you, the audience, the best opportunity to gain from their insight and experience. I also said to them, I'm only going to give them the world's briefest introduction because I could spend the entire time introducing them and all their accomplishments. So I'm not sure what order they are on the screen for you, but I'll start with Jamie Geralic, who's a senior partner at WilmerHale here in the United States, living in Washington, D.C., former Deputy Attorney General, and again, known to many of you as one of the premier litigators in the world. My dear friend Kathleen Sullivan, who we taught together at Harvard Law School when she was just a mere law professor. Then she became a dean, which is even bigger, at Stanford. And then she became a named partner in one of the top litigating law firms, Quinn Emanuel, in the world, and one of the top appellate advocates in this country. Colin Passmore, who I've gotten to know through our connection with the Thomson Reuters Managing Partner Conference, and we've had many terrific conversations through that venue. Colin is the senior partner at Simmons Simmons. I used to think before I studied lawyers that meant he was the oldest partner, but no, it just means he's the senior strategy partner at Simmons Simmons. And finally, and not at all least, because I'm so proud, Leonora Sagan is a barrister at Fountain Chambers. Fountain Chambers. I always want to put the Fountainhead on there as a UK thing, I think, or US about a UK thing. But she was also my student at Harvard Law School in the LLM program, a superstar. She's practiced both in the UK and in the US, and will represent, I hope, a view about the future that we really ought to be talking about here. But I want to start with you, Colin, because part of what got us thinking about all this was when we were talking actually about my appearing at your partner retreat, which was going to be in Monte Carlo, and we'd already picked out dinner and wine, and it was just going to be fabulous. Only the problem was it was in March. And as we continued to talk about what to do about that being postponed, you told me that you were engaged in a kind of new hybrid model proceeding on a very complex case that you were involved in. And so I said, gee, I'd love to have you have an opportunity to talk about that experience. And it turns out this is with not just you and me, but 1,000 or so of our closest friends. So Colin, will you just start and say a little bit about what the case was about, how it was organized, and what that experience was like?
Well, I think the first thing, thank you, David. I think the first thing to say is really echoing something that Richard said a few moments ago. I never in my worst nightmares thought that I would be involved in a remote trial. And when we wind back to February and March of this year, we were heading towards trial. The start date was the 8th of June, the pandemic hit. And we weren't entirely sure at that point whether the case was going to go ahead. But we'd already had two quite lengthy adjournments, and I think the parties wanted to work together to get the case concluded, as did the judge. And we had literally 2 months to prepare for this online trial. We can talk about the preparation a little bit later, but let me tell you about the trial. It was a claim by a private equity firm against the bank. The claim was in fraudulent misrepresentation, so it was a civil fraud case, lots of serious allegations. The headline claim was for £1.5 billion. There were 18 factual witnesses. There were 4 expert witnesses. We kicked off on the 8th of June. We finished the evidence on the 9th of August. We had 2 months off, and we came back in the middle of October for the oral closing submissions. And as matters stand at the moment, we are waiting for judgment. And obviously you'll understand that as I am waiting for judgment, I'm not going to say anything about the facts or the merits or anything of that sort. But the extraordinary thing that we achieved was that the judge made available the largest courtroom in our civil commercial courts in London. He limited us, because of social distancing, to 5 people in court at any one time on each side, excluding the judge, his clerk, the usher, and various tech people who looked after the technology. And the rest of us, about 10 lawyers plus clients, even more people on each side, we all zoomed in to the case. If you'd said to me in March, this is what we were going to do, I would have said to you, impossible. We got to June and it happened. And it worked. We got through to the end. We finished on the very day that we predicted we'd finished. The judge controlled the proceedings very, very tightly. There was not a single document in court. So the old days of having huge numbers of files and thousands of documents, everything was done on the Magnum document facility system that many of us are familiar with. And we used Zoom as the means of us coming into court when we weren't physically present. It was all done through a very empty London. And so actually the biggest challenge we had was arranging food at lunchtime. And I would say that on the whole, this worked extremely well, far exceeded expectations. It took a lot of preparation. There was a cost to it. We can talk about that later, but we got through it. Now, the only reason I think why in this case a fully remote hearing would not have worked is because it was necessary to undertake what one might call vigorous cross-examination. Some of the witnesses were in the witness box from 4 to 6 days. Others were in for only half a day. And I think the judge, in common with the parties, was keen, given the seriousness of the allegations and given the amount of facts that were in evidence, that he wanted to see the witnesses in person. There were 3 witnesses based overseas. They could not have come into London to give live evidence because they would have spent 14 days isolating, and that didn't make any sense. But otherwise, the vast majority of the witnesses came into London in person, and only one, a very minor witness, I think, was cross-examined over Zoom. So from me, a very big thumbs up, but you do need time to arrange this. You do need to be ready to pay for this sort of case the extra cost that having us all zooming in involves. But at the end of the day, as a process, it worked extremely well. And thank goodness we didn't have a third adjournment.
Well, thank you. That is a fascinating explanation or description of what's happening today. And Jamie, I wonder, have you had a similar experience, or lawyers in your group, because you yourself are a fantastic trial lawyer, but you also manage a very large group of lawyers. And I wonder how your experience, or the experiences that you know about, are similar or different to what Colin just described, because our systems are different.
The similarities, I think, outweigh the differences. What I did was I talked to a number of people who have had different experiences at WilmerHale, in the firm, trying cases really across the country. So I have a less personalized and more longitudinal view here. the headline for me is that oral arguments are better. Cross-examination is worse. It's very, very hard to control a witness on cross on Zoom or whatever platform you're using. So let me unpack that a little bit. First of all, I won't go into which platforms work and which ones don't, but there are real differences among platforms. Second, it is in many ways easier to adjust to what happens, quote unquote, in court. So, you know, we had an oral argument before a district court judge. We could pass notes between among ourselves, we could get up on our screens case citations and documents. All of that would have been awkward and even maybe impossible in a physical courtroom. Much easier and much more comfortable in a virtual setting. So that is very good. The lower level of formality, you know, I'm very comfortable here in my study. I think allows you to focus on the work. Although there have been some, let's just say, too informal approaches to being in a courtroom that's really your house. People say say things because they're not in the formal setting of a courtroom, which they need to watch out for. Obviously, remote proceedings are safer. I have a lot of friends who are judges, and particularly district court judges, who have talked about the difficulty of trials when a juror gets sick, a witness gets sick, infects everybody, or threatens to infect everybody. This is highly anxiety provoking. So in the current atmosphere, except for cases like cases under the Speedy Trial Act, a lot of judges are really leaning away from being there in person. Let me turn for a minute to cross. It is harder to do cross. I mean, my colleagues are unanimous that not being in the same room as the witness has just made it way more difficult. Witnesses in their homes or even in conference rooms themselves don't have the same level of formality as when they're on the witness stand. They are much more likely to stray away from the questions. And it's really harder to interrupt and to control them. And judges really have to adjust to this. And not all of them have. One expert witness told us that he prefers to testify remotely because he can filibuster on cross and not give the examining attorney a chance to interrupt him on video. Also, it's more difficult to read a witness's nonverbal cues when you're examining virtually. It also presents logistical challenges because some courts have said I, the judge, want a binder before, of anything that you're going to use to examine a witness well before the trial. And that means that if a witness says something that as to which you want to use a document to impeach, you know, that document may not be in the binder. And we had a judge who said, no, you can't use that document, which never would have happened in an actual courtroom. Also, and I'm curious about what Colin said about this, it does take longer for a virtual cross, but we end up in most of our courts with time limits on the whole case. So if it takes longer, you're eating into your own time. I want to say one word just about technical glitches. All of us have experienced technical glitches, but we had an in-person bench trial where our side had an expert who was Zooming in from Europe because he couldn't travel to Texas due to the pandemic. So he had to testify remotely, but the delays in the video and audio transmission, the stopping and starting of the proceedings, the need to get IT staff. It just didn't, that sort of hybrid really didn't work. You had a courtroom full of people waiting for the technology to get fixed. I think it's very important that courts have equal ground rules that apply to all sides. Either all the witnesses are in person or all the witnesses are remote. The bottom line of all this is that the logistical challenges really require careful planning. And we have done all kinds of things. We've had many virtual trials now over the last 8 months. How the witness is going to testify, where he or she is going to be, how the graphics get presented, what is the role of the technical professionals? Do you have to get your documents physically to people? Can you fix mistakes on the fly? We are learning a lot about how the intersection of the rules that the court sets and the technology affect the outcomes. So I'll stop there. We have lots and lots of observations. I will say I really liked, and I'm sure Kathleen will talk about this, I really like oral argument online. It has advantages that outweigh the disadvantages, but trials are tough.
Well, that's exactly, thank you, Jamie. That was so helpful. And also the interesting, I think, contrast between the US and the UK come out there a little bit, but it was exactly where I was going to go to my friend Kathleen, one of the world's premier appellate advocates. And I wonder how this is being experienced for you. Are you doing them? And is it through Zoom or through telephone? I know in the Supreme Court, they were doing telephone arguments. So tell us a little bit about the appellate court experience.
Well, thank you, David. And it's such an honor to be on this illustrious panel. Thank you for having me. I've done quite a few oral arguments now, both telephonic and by Zoom, principally in the United States Federal Circuit Courts, the Intermediate Courts of Appeal, some in district court where I've argued a resentencing and in a criminal case and a case stated hearing, which was like an abbreviated bench trial summation. And I agree with Jamie that in many ways, oral argument is much more transferable to remote formats than trial is, because after all, oral argument is a constrained, finite time period in which you have a small cast of characters assembled, usually just a few advocates and a small multi-member bench in our appellate courts. And it just doesn't involve the logistical challenges of a live trial with witnesses. So it ought to be transferable, but I would note 2 gains and 2 losses. Let's start with the losses. And Jamie alluded to this before. It's the loss of formality, or to quote from Richard's wonderful paper, majesty of the courtroom. The sense that you come in, you all rise for the berobed judges who sit elevated above the general audience and above the lawyers. The lawyers stand before the judges. The bailiff cries the court. There are guards at the door. It has a sense of enormous seriousness, and the formality and majesty gives, I think, a lot of comfort to litigants that their case is being seriously entertained. It's not just a day at the office. It's a major public event. That is lost. That sense that you've come to the court, and clients often want to be at the oral argument. I often wonder, why are clients so interested in the oral argument when it often takes 10 or 15 minutes in an American court? An hour is a long argument. When we invest so many resources in preparing for oral argument. And I think the main reason is for the client, there's a dignitarian aspect to being heard in front of the decision maker, face to face, where you can see their body language and understand their responses to you. So that's gone. We have it's all intermediated now. We don't have that sense of formality. Whether that's important, Richard asks in his paper, is majesty a goal of the court system? Is court a place or a service? And I think that's a legitimate question, but it is a big difference. And the second loss is of spontaneity. In oral argument, the fun part of oral argument is what I think of as jazz. It's all about improvisation. It's all about doing the music you've rehearsed so well. I think thinking very much of David's background here. You do things in an order as they come up. It's a conversation with judges where you have to improvise and respond to a spontaneous sequence of questions where there are interruptions. There are no interruptions on Zoom, or if there is an interruption, it's awkwardly overcome quickly while one judge defers to the other. And so that sense of engagement and spontaneity where you think you might change minds in the heat of the moment is gone. The gains, the two big gains are efficiency, obviously. Enormously efficient to be able to zoom in. Courts could theoretically have many more oral arguments per sitting and accomplish the moving along of the caseload. I think the biggest concern in American appellate courts is the length of time from filing to disposition, which is unpredictable and varies among courts and takes a terribly long time with written opinions. You could theoretically have much more efficient processing of appellate matters if you use Zoom arguments, because you at least decrease the wait time for argument. And I think that could be a source of future gains. And the second gain is coherence. What you lose in the spontaneity of argument, you gain in the kind of orderliness of the questions. Rather than jazz, we have a kind of conducted chamber music where the presiding judge does a lot of, makes a lot of efforts to make sure that each judge has had his or her questions a chance to be answered. So yeah, and it's highly formalized at the US Supreme Court, where the Chief Justice of the United States asks each justice in descending order of seniority to ask a question. And of course, famously, Justice Thomas, who hasn't participated in the free form arguments, asks excellent questions now to many, and some people like that sense of orderliness that come with the questions. So I think appellate argument and legal argument in the district courts has adapted well to Zoom, but I think the questions to ask going forward is, could the technology be used for greater efficiency? And is there a downside to not having that sense of live interaction with the decision maker, which gives authority to the judgments of the court?
If I could just comment for a moment, David, you've encouraged us to do this.
I have.
On Kathleen's excellent remarks. I'm not sure I can extend the musical metaphor, so I won't try. But I actually have found that district court judges are pretty spontaneous, and there is a back and forth. The Supreme Court there are 9 of them. It's not going to work to let them interrupt each other the way they do when they're physically present. 3 judges on an appellate court is somewhere in between. My feeling, Kathleen, is that if we keep at this, there will be a little more spontaneity than we're seeing, than we saw at the beginning. I've seen it loosen up, and I've seen interruptions and interactions in a way that make me a little more optimistic about that.
So Jamie, I do agree with that. My first experience, I gave my last live oral argument February 13th, and I had to do my first remote oral argument a few weeks later, and it was telephonic because the courts hadn't gotten up and running on Zoom or Zoom for Government yet. It was awful. It was just awful. I couldn't see who I was talking to. I had studied the voices carefully, but I still wasn't always sure which judge was speaking, and I couldn't see their reactions. Zoom is immensely better because you can see their reactions. You can you can see if they're smiling, if they're laughing, if they're eager to ask a question, and if you've registered with them. So that's an immense gain, I agree. And I think judges are getting used to it and more comfortable with it. So there's no reason to think that some of these old features of live oral argument can't be more and more introduced as we get more familiar with the format.
Well, I think that's an
David, could I just jump in and pick up a point that Jamie made? And really to echo what she said. Forgive me for interrupting, but
Please,
the biggest challenge, it seems to me, with remote hearings is persuading a majority of lawyers that the cross-examination of witnesses is as effective over Zoom or whatever medium we use as opposed to in person. And I noticed that 1 or 2 people have posted questions about the effectiveness. I think picking up something I said in my case, where we had 3 or 4 witnesses overseas, factual witnesses overseas. We were blessed in that the connections all worked on those days, thank goodness. And there were a few days when we lost time and the judge was very good and made it up. And somebody posed the question, well, how do you know there's not someone in the room coaching them? And I'm afraid the answer to that is you come down to trusting your opponents that they will do what they are supposed to do under the rules. And there was just no question in our case that anyone was going to try to bend the rules. It never occurred to any of us. But there is no doubt that we found that the cross-examination of the live witness with the advocate, the cross-examiner, and the person being examined in front of the judge was so much more effective. And I think that is the biggest challenge we face in terms of remote hearings. I totally get everything, and I agree with everything that's being said about oral hearings. That's much easier. But it's the moment you have a witness, and that's going to apply, I think, to criminal trials, there is this sense that you need to see that person. You need to look into the whites of their eyes.
I agree with that. David, if I can just jump in there, because I think I have a good example of exactly where this happened.
Yeah.
So the issue in my case was whether a witness to a New York arbitration who lived in England could be compelled by the English courts to give evidence in support of that New York arbitration. And in March, we took that question to the Court of Appeal, and the Court of Appeal said yes. But of course, that was a few days before our first lockdown. So then we're in lockdown and we're having to examine this witness on Zoom. And the entire purpose of this examination was the credibility of this person. The question was, were they lying about what happened at this meeting some years ago? And the broader context too was, the arbitration was about bribery. There were issues of credibility, of honesty, allegations of fraud. And unfortunately, on this occasion, it just really didn't work. So cross-examination, picking up on Jamie's point, was really stunted. Advocates couldn't even get the tempo or the rhythm up that you can get sometimes when you're in the same space as a witness. There were technical glitches and loss of sound. There was the inevitable, I think, to some extent, loss of atmosphere. And I think the point that Colin was making before, I agree with. It's so easy to underestimate how much of the court's assessment on credibility and honesty is about facial expressions. You can sometimes see the tension building up in the shoulders and in the neck. You can see the flush in the face. And a good advocate can really sort of move that momentum to their advantage. And unfortunately, on this occasion, it really didn't work. But I will say one other point, Colin, and this also comes back to your point about how do you know what's going on in the room? In our case, I think some of those issues were about a lack of standard directions. So it was just after lockdown, and the court didn't have directions as to where should a witness sit, how far away from the camera should the witness be. And so odd things were happening, for example, like, on Zoom, it spotlights the person who's talking. But sometimes when the advocate is asking the question, you want to be looking at the witness, right? You want to be seeing what's going on in the face of the witness. And of course, you can do that on some platforms, including Zoom. But those things, I think, if we get further down the line of having standard directions, because we've experienced this many, many times, some of that will be improved on. But I think the central point about needing more work to be done in witness handling is just going to be there for the long term.
In our case, we always, so on the days when I was remote, i.e. working at home, we had three pictures always: the judge, who was center, the advocate to the right or the left, depending on how you see me, and the witness in the witness box over this side. And one of the little funny side effects was when we first had these hearings, I would turn up like this, wearing a suit, but with shorts underneath, which nobody could see. And none of us realized that the judge was going to order on day one, turn your videos off. And the moment he ordered that, all of us working at home just resorted to t-shirts and shorts and running kit. And it was just left to these three people in the courtroom that, as Kathleen was saying, to sort of project the majesty of the proceedings.
Well, but I think that actually gets to the next point that I want to talk about, which is, so how should we be preparing for these now? Because I think most people think even after the vaccine, it's not as if this is going to go away. right? It's probably not going to be as much as it is now, but I think it's very unlikely that all of the remote things we're doing in work generally are going to go away. And that then raises the question, what do we do to prepare ourselves to do this better? And, you know, Jamie, you were talking about different platforms and standardization. And Leonora, you're talking about different rules about how people sit or how people are displayed. And I wonder if that's something right now, Jamie, that you're thinking about with your lawyers, and love to get Kathleen and others in there as well.
Well, we have real lessons learned. I mean, you know, when you have 500 litigators and you've done, I don't know how many, we've done probably 10 Zoom trials and then a bunch of hybrid ones. We now have lessons from this. And so we now know what we need to ask the judges to do. And that has a lot to do with evening the playing field in ways that you wouldn't have contemplated before. So that's number one. I think, and this is probably a plug for Harvard Law School, we need to train the judges. I mean, they don't know how to do this, and some of them are, you know, older than some of the rest of us, and so the technology is doesn't work for them. I mean, it would help a lot if you didn't have to put binders physically in front of them, because it actually disables you from the agility that you need in a trial. So I would say, you know, we need to figure out what best practices are, and we advocates are, you know, part of making that happen. But honestly, there have to be within the courts some sense of best practices and how it is much harder to get a fair proceeding. I mean, these things that we've been talking about, they fall unevenly, just almost randomly on different parties and different advocates. So I think there's a lot of work to be done. I still think that if you think about lasting consequences, and Kathleen talked about this, I think the efficiency of oral arguments in online platforms will be attractive to people. I mean, I'm sure that Kathleen's not the only person who's flown across the country for 15 minutes of argument. You know, that drives clients nuts, and rightly so. So it may be that we'll be in a hybrid world, even when it is safe to come out from under the pandemic. The trial world, I'm not so sure. There may be some pieces of it, and in this interregnum, we need to work to get it right.
Kathleen, any thoughts from your point of view? Because I thought you really, as always, painted a very interesting tension between the efficiency argument and the ability to actually interact and persuade. And so I wonder how you're thinking about that. Short of, Jamie says, train the judges. I think that's a good idea, but you probably don't have the ability to do that, at least just yet. So how, or maybe you train them through the way in which you or your lawyers interact with them. So how are you thinking about that, the preparation phase for doing a virtual hearing of some kind?
Well, I think that one of the profound lessons of this time is how collaboration among our teams is easier to practice in a remote environment. I think Jamie alluded to the idea before that the team could communicate in a trial setting among itself while the hearing was taking place remotely. And that's also true in oral argument. I was able to communicate with my team during the argument by the discreet use of email off screen. And in fact, this was extremely important in the sentencing hearing, where I was remote to the courtroom, but one of my colleagues was in the courtroom with the client. And my colleague in the courtroom was able to tell me, the judge is not taking notes now. You don't need to rebut that point. Or, you know, we're done with that point. And that sort of communication, I think that could be systematized. My colleagues who've conducted now virtual bench trials, a number of virtual bench trials, among the first in the Delaware Chancery Court, which involved enormous numbers of documents. I think the teams have gotten very systematic about how to collaborate during a live event by efficient sharing of documents and preparation to share documents. So I think the training, we have to just accelerate an advance toward technological cooperation among lawyers in ways of presentation. And this can actually, I think, have a great structural effect of elevating the importance of junior members of the team. You know, the standard practice in oral argument is a senior lawyer gets up and gets to be the face of what is usually an enormous team effort. But now in real time, the team has more importance in conveying the ideas. And I think that can advance the careers of young lawyers more quickly as they become more integral parts of presentations during remote arguments. So also, they know how to use the technology better. When you want something done right technologically, you have to look to the younger lawyers.
Yes, this is why my Zoom studio was set up by my son. So, but Leonora, I think that's your cue to tell us kind of, you know, as part of the generation that my colleague John Palfrey, who now runs the MacArthur Genius Foundation, called Born Digital. How is it, what are the advantages we should be moving towards? That is, Richard, I think in his talk, and one of the things I always love about Richard is he's always looking out over the horizon and asking us to think about how do we move to a world in which we're not just trying to replicate what we already do in person online, but taking advantage of that. And are there opportunities that you see, either that you have been able to do or that you can see being able to do in this new world?
Yeah, I mean, so there are two separate points, David. I think just briefly on challenges, and then I promise to be optimistic. The point Kathleen was making about junior lawyers, I think, does cut both ways, right? Because all of a sudden, overnight, when you only have one advocate being spotlit, the team sometimes becomes invisible. Quite literally, the junior lawyer who would have been physically present with you in the courtroom and the bench can see and the client can see has become invisible. So we have to become more creative about the ways that we become visible and the ways also that we network, because outside of just the hearing for junior lawyers, that challenge of building rapport, of building long-lasting connections has gone, really. You don't have the walk to court with your leader. You don't have the lunchtime chat with a solicitor. You don't have the client meetings. And that can be very difficult when you're actually trying to build the career. How do you get rapport? How, without a physical presence, do you build that community of lawyers who's going to be your support network? But, you know, on opportunity...
Just Leonora, I'll just say that point is so critical. And I bet Colin and everybody and Kathleen and Jamie will say the biggest challenge I think we're going to face is how to junior lawyers build senses of community. And that's particularly true for junior lawyers who are from diverse backgrounds, you know, women, people of color, who already have challenges building informal networks and relationships and being visible and all of that. So I'm very glad you raised this issue, because I think this is one that often we forget in the drive to efficiency and, oh, everybody can be at home. So it's a really critical point. But please go ahead. Now you're going to be optimistic. You promised.
So on optimism, I think, you know, I tend to side with Richard that the greatest opportunity here is about access to justice. And at least in the UK, what I've noticed is that in the criminal sphere, there are some real opportunities here. And I know crime is a little bit beyond the sort of remit of the talk and also Richard's book. But when we're talking about access to a system that's, you know, intelligible and affordable and accessible, and where the stakes are loss of liberty, I think we can really start being super creative about where we take this in the future. So to give you a small example, at the moment I'm representing a defendant in a market abuse prosecution. And only because of the pandemic, all of the preliminary hearings have taken place remotely. But the absolute assumption in the UK courts is that even preliminary hearings in the criminal sphere will take place in person. Now that strikes me as, to some extent, a lack of imagination. In this case, we have 3 defendants, 8 counsel, living quite far apart, and many, many preliminary hearings, some of which take 10 minutes. So you turn up to court having traveled 3.5 hours on a train as a defendant, you're already nervous, potentially vulnerable, if you're a minor or if you are otherwise vulnerable mentally. And it seems to me that the biggest opportunity is that if this pandemic can shift the paradigm so that at the very least, just the assumptions we make as to what hearings can take place remotely and which need to be in person will actually be doing quite a bit better than we have been. And I'm not going to touch virtual juries because that's a whole nother debate.
Well, that's where I have to go. And I was going to just about ask Amy this because, of course, in our system, that's not just a criminal matter. And, you know, actually, unfortunately, she could not be here for this conference, but one of our former students, I'm very proud of, just did the first virtual jury trial in Texas. And she's actually going to come to my class on this subject next week. But that is the issue that is now being put on the table. And I wonder, Jamie, how you think about that as a trial lawyer of both civil and criminal cases.
I think it's really hard. And of course, this would, these changes would require legislation. We have our criminal defendants have a right to be present. And then they, of course, we also have the Speedy Trial Act. So we have lots of imperatives in our statutes that would impede movements in those directions. I think we need to power through the pandemic and then get the highest priority cases back into courtrooms which are set up for them. I would like to comment on Leonora's comment about the inclusion of younger lawyers. So number one, it's my experience that you can have quite a few people on Zoom in a hearing or at a trial. And so you could actually have maybe more people present for what would be a 15-minute argument or a 3-week trial than you might otherwise have. They can't go out for a drink after a hard day, but they can at least participate. Second, the pandemic has engendered a great deal of ingenuity among the younger lawyers and professionals. We had an in-person trial in the Eastern District of Texas in August, which I won't say anything more about that. And our paralegal team hired a huge wedding venue for our war room. It was like a big barn. We called it the war barn instead of the war room. And it allowed our people all to be in the same place, but, you know, socially distanced with a lot of outdoor space to have meetings. So I think this pandemic is triggering a lot of ingenuity about how to keep a sense of the team and how to get the teams to work together and how to make sure that all parts of the team are working together.
So, Colin, I wonder what you think about that, both how you manage that, because it sounded to me like this was a multiple defendant thing in which there were different lawyers representing different parties in different places. And then, of course, you yourself must have had a very large team, maybe spread across multiple jurisdictions. So how did you kind of manage that? And where do you see the opportunities? Again, what kinds of things do you see moving forward that you can learn from this experience that actually might even be there, even if you could be all physically together?
Well, I think, first of all, I agree with both Jamie and Leonora about the pluses and minuses of involving younger colleagues. We found it very easy. We had 30 people at any one time watching in over Zoom. But I do think that personal element is starting to come very much up the agenda. And I'm finding with our second UK lockdown that the great goal of permanently working from home isn't going to work, because you know what, we are all social creatures and we are missing being with other people. And I don't think that we are all going to want to continue to do wholly remote trials. There is something about that in-person contact. Nonetheless, what we found as the positives with a remote trial was, I think as Jamie said, our colleagues sitting in their desks like this could make as much noise as they like, tapping away on the computer, finding documents, finding precedents. It was absolutely brilliant. the way we were sitting in court and all this information would come pouring in. And then we also had separate WhatsApp channels. You know, the advocate's got that wrong. He's on the wrong page. Don't let him make that submission. So we used all of that. And I think that has all been terribly effective. Can I mention, however, one other category of person who I think sometimes gets overlooked in this, and that is the client.
Yes.
And the client is the one paying for all of this. And we found that there was a certain amount of frustration with our hybrid setup, in as much as there simply wasn't room for the client in court, because there were so many lawyers, there were so many facts, so many documents, albeit virtual documents. So the client had to give their instructions over WhatsApp, and sometimes things just went slightly off the rails. Not seriously, but there was a frustration. And in the end, when we came back to the oral arguments, which were in person, so Kathleen, I don't know if this will surprise you. At the end of a first instance trial, we had 5 full days of oral arguments, having been preceded by a 200-page document on either side. So the clients decided that for that, although we were then moved to a smaller courtroom with fewer people in it, we then hired some rooms outside. And so we'd be sitting in like this, watching in, zooming in, even though the judge was literally 10 feet away in another room. And that helped us get the clients much more closely involved. So I think we're going to have to think about all of these things, but there is no doubt that remote trial working is here to stay. And when you think, one of Richard's points earlier, if you had said to me in February, I'm going to be on a Zoom call with David Wilkins, don't be ridiculous. I hadn't even used Business for Skype. I was still using a telephone. And Business for Skype, it's history, isn't it? And now we're using this wonderful technology. And I think the English courts, having started to use Business for Skype, quickly came to realize, and certainly in our case, that just would not cope with a lengthy hearing. And we had to spend a little bit of time persuading the judge that all those security concerns that used to exist about Zoom could be overcome, had indeed been overcome. So I think there's positives. I certainly agree with Jamie that it enables us to show younger lawyers examples of trial experience, what it's actually like. And you do retain a lot of what was there in the old days, but there is that sort of social connection bit. We do need to think about that. And I worry about that generally, not just in the trial context. I think having, the new trainee lawyers who joined my firm in August, 20 of them, they haven't met anyone in person. That can't go on, can it?
So Kathleen, that's kind of what I wanted to turn to you, because you've been both a brilliant teacher, run a legal institute, one of the top law schools in the world, and now are someone who really cares deeply about the training and development of young lawyers. I know that. Looking forward again, and kind of as we come towards the end of our time here, we have about 1,000 people on this call who some are judges, some are law professors, some are litigating lawyers, some are my students, and I hope other students as we've tried to spread the word. And so as you kind of look forward from the roles you've played in this, how do you think we ought to move forward into this kind of uncertain future we're headed to?
Thank you, David. And my heart went out to Leonora on her comments about young lawyers, because I agree with Colin very much that we're social creatures, and a great deal of the teaching that I've been able to do as a practicing lawyer, and I love to teach, that's where I began my career, is very much dependent on these live interactions, moments when you can coach a person who's practicing an argument in the room and stop them and say, do it again. And that's a little bit more difficult over Zoom, but I am optimistic that actually young lawyers can get more exposure through remote technologies if we pay attention to it. First of all, I think the point that you can have many people on Zoom, as Jamie pointed out, is a very important one. I have often now in client meetings gone to the trouble of introducing all the young lawyers by name and describing their contributions so that the Zoom appearance of the person doesn't seem mysterious. And that sometimes gets overlooked in the live meeting where you get right to business. So I think, first of all, young lawyers can get a better set of introductions to clients. Second, I think young lawyers can have more opportunities to make arguments via Zoom technology because it allows you to split up the arguments, even if people are in remote locations. By this, I don't mean a single appellate argument, but where there are multiple discovery motions in pretrial proceedings and that sort of thing in the American civil system, that you can multiply the number of speakers readily on Zoom. And I think the third point is that young lawyers have to embrace this technology and work on presentation skills. And there are better and worse ways to do Zoom, putting aside lighting, camera placement, camera setup. And I've been astonished actually in the number of arguments I've done, how differentiated the technologies are. Sometimes I've watched my adversaries go to great trouble to have an elaborate camera setup in an office, but then it's controlled by a tech, and the tech and the lawyer don't necessarily communicate, and the lawyer is sitting, standing at the wrong times, and it's far better to get a command of an excellent camera setup that you can control yourself. But that's just the beginning. Put aside the technology. What I think young lawyers have to do is embrace this as a way to develop crisp and efficient speaking styles and ways of compressing their arguments into forms that may only get a brief moment to express themselves. You know, things we do take a tremendous amount of time, too long. They go on forever. Although I am jealous of Colin that he gets to do 4-day oral arguments. I'm jealous about the British system. The first time I went to the Palace of Justice when I was a baby law professor as a guest of a Harvard alumnus who was a distinguished Queen's counsel, and he took me to court, and the oral arguments went on forever. The judges declaimed the decision from the bench. I was astonished. I said, that was amazing, that oral argument. We have to submit, and we wait a long time for the opinion after a brief oral argument. And he said, yes, we in Britain have always wondered why you Yanks rely so much on the briefs and so little on the oral argument when you speak so well and write so poorly. I begged to differ on whether we wrote poorly, but you know, I'm jealous of the lengthy oral arguments. But in a system where most of our oral arguments are very brief, I think this is a time for young lawyers to learn how to be extremely effective in quick sound bites and learn to maximize their effectiveness. So I think we can do a lot of training via Zoom. I try to spend more time with my young lawyers going over drafts and why I change things in Zoom calls than maybe I would have done live. So I hope there's some silver lining in all of that, David.
Thank you. And actually, when my interviews with lawyers, many people do report that they're seeing their senior people more, in part because the senior people are more cognizant about checking in.
Absolutely.
It's actually easier to do so. So I'm just gonna go around the rest of you, and I'm gonna start with Jamie and then Colin, and then I'm gonna let Leonora speak for the future at the very end. Just any final thoughts that you might have for this amazing audience that we've put together about where you think we should go and what can we do to learn how to embrace the best of what we have here?
Well, I think we've covered a lot of that here. I think that online courts for oral arguments are here to stay. I think the days of flying across the country to do a 15-minute argument are numbered. And I think that the convenience of having input while you're arguing, but that's unseen by the court and anyone else, is just fabulous. So as Kathleen said, you have to kind of change your style a little bit, but the benefits are there. I am really dubious that we will embrace online trials, particularly as they require cross-examination. The downside of it is huge. In this interregnum, I think that we, anyway, within WilmerHale, have lots of lessons learned about how to do this and how not, what to ask the courts to do and not. And we will just do the best that we can. But my own view, both for the pandemic generally and for the impact on courts, is to just power through this pandemic and then get to a place where we can say, what do we keep and what do we jettison?
Colin?
Very difficult to add to that, because I agree with everything that Jamie has just said. I think there is a huge saving to be had on interlocutory hearings or hearings that don't require witnesses. I think a key, however, to learning the best is ensuring or having a judiciary that embraces these changes. And at least we in the UK have got a new master of the rolls who's speaking to us later, who has given a speech in the last few days about how he's going to shake up civil justice. And I am pretty confident. I have no idea if he's listening, so I'm not saying this to be on his good side. Even if he's not listening, that is exactly what we need. We need the lead from the top, and I hope the top will then talk to us in the middle, and then change will start to come through, and thank goodness for that.
And finally, Leonora, my representative of the future.
Yeah, I mean, I think I would maybe end on an even more sort of radical note, taking a leaf out of Richard's book, quite literally. I really like his idea of extended courts, you know, moving beyond litigation to a situation where courts can actually empower citizens to diagnose their own problems and then to use court systems to solve them. So I think on litigation, I agree with everybody else on this panel. Trials are going to be difficult, appellate advocacy much better. But even further into the future, I think the idea of actually using the courts as systems that can help citizens solve their own problems, I'm very excited about that.
So I love that optimistic note. I'll just end by saying this before I thank this amazing panel. What I told my students on my first day of teaching this September, teaching fully remotely, actually I told them two things. One, I had never been more scared about a first day of class than when I had my actual first day of class, which Kathleen will remember, in 1986. And the second thing I told them I said, we're going to kind of treat this like the advice, I don't know if any of you got, but I got when I got married. We're going to have something old, something new, something borrowed, and we're going to try not to be blue. So the something old is we're going to figure out what are the best things that we used to do in person and what can we replicate? But we're going to try liberally to do new things online. And I do think there are a number of things that can be done. I'll just say in my class, I had all my students record 1 to 2 minute videos about themselves, which we show at the beginning of every class. And I'm now quite confident we know more about my students than we ever would in an ordinary classroom. We're going to borrow, or more accurately, steal every good idea, and the rest of the world is way ahead of us in thinking about how to use digital platforms and online learning, particularly in adult context. And when you're doing an oral argument, you're teaching the judges in an online adult education format. You don't have to say that, I do. And then we're just not going to be blue. We're just not going to see the downside of all this. We're going to try to see what can be good about it. And this panel, notwithstanding pointing out the problems, just makes me more optimistic than ever that with incredible lawyers like we have here, that we're going to find ways to find what's best about this. I know I speak for everyone. If this were in a hall with 1,000 people, there would be thunderous applause coming. Even if we were in a regular Zoom call, there would be lots of little yellow hands, you know, clapping like this. But you'll just have to settle for my deep thanks for all of you taking time out at different times of the day, particularly my friend Kathleen, who had to get up about 6 o'clock in the morning to do this from California, and our folks from the UK in the evening. So thank you very much. If you can stay for the rest of the event, we would love if you can. I hope we could be engaged about these arguments and issues moving forward. Any thoughts you have afterwards, please let us know. But otherwise, you know, thank you very much. Court is over. Thank you. Bye-bye.